So good day, everyone. Today we're going to discuss on alternative circumstances as well as who are the principals, accomplices, and accessories. I hope everyone sees this one. So first we go into Article 15. Just to remind you of what is Article 15. According to the Code of Provisions, okay, uh, Article 15, alternative circumstances are those which must be taken into consideration either as an aggravating or mitigating circumstances, so, according to the nature and effects of the crime and other conditions attending to its commission. So what are the alternative circumstances? So they are the following. Yun, merong relationship, okay? That's number one. Second is intoxication. Third is the degree of instruction and education. So when you talk about relationship, sige, relationship, ito sinasabi nila, according to this law, 15, it could be taken as aggravating or mitigating circumstances. So when you talk about relationship, lahat ba ng kamag-anak? No. Only when the offended party is the spouse, ascendants, descendants, or your legitimate, natural, adopted, brother or sister, or relatives again by affinity within the same degree of the offender. So it does not include relatives by consanguinity within the fourth civil degree. Yung consanguinity within the fourth civil degree will only be applicable to the defense of a relative under a justifying circumstance. But insofar as alternative circumstances are concerned, relatives are only limited and up to relative by affinity within the same degree. When you talk about intoxication, okay, it is considered as mitigating, okay, when the offender has committed a felony in a state of intoxication for as long as it is not habitual or subsequent to the commission of the crime. Okay? If it is habitual or subsequent to the commission of the felony or it was used intentionally to embolden him, then it shall be deemed as an aggravating circumstance. Okay? So remember all those concepts. It could be used as a mitigating. It can also be used as an aggravating circumstances. Relationship, intoxication, degree of instruction, and education. So when you talk about relationship, let's go into the detail. As I mentioned to you, it's limited to those which I enumerated a while ago. Okay. So when is relationship mitigating and when is it aggravating? The law actually is silent as to when the relationship is mitigating and when it is aggravating circumstance. So as a rule, relationship is mitigating in crimes against property by analogy to the provision of Article 332. Okay? So the relationship is mitigating in the crimes of robbery, usurpation, or fraudulent insolvency. Pero kung titingnan nyo specifically yung Article 332, no, it is not only deemed as mitigating circumstance. Generally, really, when it involves crimes against property, it is mitigating, except in Article 332, no, because in Article 332, there is no criminal liability if the crime is what? Theft, estafa or swindling, or malicious mischief. Okay? And there is no criminal liability. It is an exempting in Article 332, but only civil liability. It is aggravating in crimes against persons in cases where the offended party is a relative of higher or of a higher degree than the offender, or when the offender and the offended party are relatives of the same degree, as killing the brother or brother-in-law, half-brother, or adopted brother. Okay? Pero titingnan nyo kung may, pag may child abuse, ibang usapan na yan. Is relationship not aggravating when the offended party killed his brother-in-law? Okay? Except an admission by the accused, that the deceased was his brother-in-law, relationships by affinity should not be deemed to aggravate the crime in the absence of evidence to show that the offended party is of higher degree in relationship than that of the offender. If the crime against persons is any of the serious physical injuries, okay, the fact that the offended party is a descendant of the offender is not mitigating. Is not mitigating. Uh, if if the offense of serious physical injuries is committed by the offender against his child, whether legitimate or illegitimate, or any of his legitimate other descendants, no relationship is aggravating. When the crime against person is homicide or murder, relationship is aggravating even if the victim of the crime is a relative of lower degree. So, yun, pagka-murder or homicide, hindi na dinedetermine kung higher degree of the same degree. Basta, ano yan, relationship is aggravating. Okay? So, if the commission of the crime against persons resulted to death of the victim, no, whether of relative na same degree, higher degree, lower degree, immaterial, no, relationship is an aggravating circumstance. So, alimbawa, the killing of a stepdaughter by her stepmother is, if it, of course it is attended to by relationship. Is it deemed aggravating, mitigating? It is deemed as an aggravating circumstance. The crime is not parricide kasi hindi naman direct line, di ba? Because relationship is not by blood and the direct line. But the relationship was considered, no, is to be considered as an aggravating circumstance. And this is notwithstanding the fact that the victim was of lower degree. What about in trespass to dwelling? Okay, halimbawa, yung son-in-law, uh, naniniwala siya na yung kanyang asawa ay nasa house kanyang father-in-law. So he forcibly tried to open the door. Okay? And is it aggravating or mitigating? Relationship is mitigating in trespass to dwelling. So remember that. What about if relationship is an element of the crime? Okay, do we treat it as a mitigating or aggravating? Hindi. Diba? Relationship is either mitigating or aggravating, no? If it is an element of the offense, like in the crime of parricide, no? In the crime of infanticide. So, yun. But more on parricide. In crimes against chastity, relationship is always aggravating. So, walang ano yun, walang mitigating doon. Mag-anak mo yan, always aggravating. So, like rape or acts of lasciviousness, relationship is always aggravating. What about a stepfather raping his own stepdaughter? Okay, relationship is aggravating in case where a stepfather raped his stepdaughter, or in case where a father raped his daughter. Okay, so what are the important principles to consider sa relationship? Okay, relationship of stepfather or stepmother or stepson or stepdaughter is included by analogy as similar to ascendants or descendants. So same ano yan ha, by analogy, kasama sila dyan. Okay, relationship again is mitigating in crimes against property. But in estafa or malicious mischief, theft, relationship is exempting. Relationship is aggravating in crimes against persons, even if the party is a relative of higher degree or when the offender and the offended party are of relatives of the same level. So aggravating yan in crimes against persons. Okay? But tandaan nyo, if the relationship is an element of the crime, as I mentioned, as in the crime of parricide, no, it is neither aggravating nor mitigating. Kasi element na ng crime yun. In crimes against chastity, relationship is always aggravating, whether the offender is of higher degree or lower, it's immaterial. Okay? Because what is considered is here is the nature of the crime. Okay? So tatandaan niyo yun. Now let's go to intoxication. Sinabi natin kanina, it depends of whether it is habitual or subsequent to the commission of the crime. So if it is subsequent to the, if it is uh, not habitual, ayusin natin. It is mitigating if intoxication is not habitual or it is not subsequent to the plan to commit a felony or subsequent to the commission of the crime. Baligtarin natin, it becomes aggravating. So if intoxication is habitual or if it is intentional, when we talk about intentional, it is subsequent to the commission of the crime or a felony, then it is aggravating. Okay? When it is intentional, if the offender drinks liquor, knowing fully well its effects, to find in that liquor a stimulant to commit a crime or as a means to suffocate any remorse. Of course, drunkenness must affect mental faculties. Tandaan niyo. When we talk about habitual, the habit should be proven. The habit should be actual and confirmed. But it is not necessary that it be continuous of a daily occurrence. Hindi naman dapat hindi naman necessarily araw-araw. Pero nakikita na habitual yun or regular. So even if intoxication is not habitual, again, it is aggravating kung subsequent naman to the commission of the crime. So what will be the reasons for this alternative circumstance of intoxication? As a mitigating circumstance, it finds its reason in the fact that when a person is under the influence of liquor, his exercise of willpower is impaired. Alam natin yan. As an aggravating circumstance, because it is intentional, the reason is that the offender resorted to it in order to bolster his courage in order to commit that specific felony. It is aggravating when intoxication is habitual because the constant use of intoxicating liquor lessens yung individual resistance to evil thoughts and undermines the willpower making of that person. So this is based on the decision of the Supreme Court. What is the presumption? Presumption is that Ano ba yan? Pag intoxicated in tao, is it habitual? No. Presumption is that intoxication is accidental. It is only in the absence of proof to the contrary, it will always be presumed that intoxication is not habitual but merely accidental. And the fact that the accused was drunk at the time of the commission of the crime must then be considered as a mitigating circumstance. So, again, important things to consider. Okay? Intoxication is mitigating if it is not habitual or it is not subsequent to the commission of the crime. It is aggravating if it is habitual or intentional. And again, by intoxication, remember, dapat apektado yung kanyang mental faculties. And the state of intoxication must be proved. Okay, intoxication is not present when there is no showing by the accused that his reason was blurred to the extent that he was deprived of that degree of control of himself. Now let's go to degree of instruction and education. Rules. What are the rules? Low degree of instruction and education or lack of it is what? Generally mitigating. It is generally mitigating. High degree of instruction and education is aggravating when the offender avails himself of his learning in order to commit the crime. Okay? Lack of sufficient intelligence is required in illiteracy. Pag tayo hindi nakapag-aral, ibig sabihin ba yon ay mitigating agad? Not illiteracy alone, but also lack of sufficient intelligence are necessary to invoke the benefit of this lack of instruction, the determination of which is left to the trial court. Lack of instruction must be proved by the defense. Okay? Because this is a mitigating circumstance. The mitigating circumstance of lack of instruction must be proved positively and directly and cannot be based on mere inference or deduction. The question of lack of instruction cannot be raised for the first time on appeal. It is not mitigating, however, in crimes against property. Tandaan niyo, hindi siya mitigating in crimes against property, hindi rin siya mitigating in crimes against chastity. Okay? Hindi naman, well, self-explanatory na yan. No one is so ignorant as not to know that the crime of rape is wrong and in violation of the law. What about in murder? Nag-raise ang defense ng lack of instruction and education. Okay? Is it mitigating? No. Lack of education and instruction is not mitigating in the crime of murder. Lack of education and instruction cannot mitigate appellant's guilt because to kill is forbidden by natural law, which every person, every rational being is endowed to know and feel. Degree of instruction is aggravating when the offender availed himself or took advantage of it in committing the crime. Katulad ng abogado, who abuses education, tapos by committing the crime of estafa. Let's go to important principles to consider. Again, tandaan nyo, importante dito, in the degree of instruction and education of the offender, the court considers not only illiteracy, but lack of intelligence of the offender. Kasi it is not the illiteracy alone, but the lack of sufficient intelligence and knowledge of the full significance of all acts which only the trial court can appreciate that constitutes the mitigating circumstance of lack of instruction. Okay, so tatandaan nyo yun at hindi ito mitigating also in the crime of murder because alam naman natin na at no instance na except yung self-defense na bawal, forbidden by natural law ang pumatay ng tao. At hindi naman mitigating in crimes against property like robbery or theft, nor in crimes against chastity, okay, like rape, nor in the crime of arson. So hindi naman pwedeng gawin nilang justification, ay hindi ako nakaaral, kaya ako ginawa yung robbery, theft, okay, crimes against chastity, or rape. No. No one, however, unschooled, no one, however unschooled, he may be so ignorant as not to know that the crimes of theft or robbery, or is inherently wrong or in violation of the law. Okay, let's go to bar exam. Okay, so kinanong a question. A was invited to a drinking spree by friends after having too many drinks. A and B. This is based on my book. A and B had a heated argument during which A stabbed B. So as a result, B suffered serious physical injuries. May the intoxication of A be considered aggravating or mitigating? So, yun lang, yung sinabi natin. So, we lay down the legal basis. This is the root. Intoxication may be appreciated either as a mitigating or aggravating under the following rules. Mitigating if intoxication is not habitual and not subsequent to the commission of the felony. No? In the case at bar, the stabbing incident arose by reason of the heated argument and was merely incidental and not intentional to the commission of the crime. Okay, so this being so, also it is not habitual or since he only drank liquor upon invitation of friends. This being so, then the crime is then it is deemed merely as mitigating circumstance. So let's go to Title 2, Persons Criminally Liable. So who are the persons criminally liable? The following are criminally liable for grave and less grave felonies. Principals, accomplices, accessories. And the following are liable for light felonies. Principals and accomplices. Hindi kasama ang accessory. So remember that an accessory is not liable for light felonies except when it involves crimes against persons or property. So i-connect mo doon sa previous discussion on what light felony is all about. The following are the principles. So ang daming beses itinanong sa bar ang principles. That means to say, bilugan nyo yung Article 17. So we have the following are considered as principles. Number 1, those who take a direct part in the execution of the act. Number 2, those who directly force or induce others to commit the same. And third is one is by indispensable cooperation. I need to make a thing. Those who take a direct part in the execution of the act is called as principals. A principal by direct participation. So classes of principals. Number one, principal by direct participation. Number two, those who directly force or induce another to commit the crime. It talks about principal by by inducement. Third, talks wala dito yung kuda lang. Principal by indispensable cooperation. So these are the three classes or three kinds of principals. Number one, principals by direct participation, principal by inducement, principal by indispensable cooperation. So principal by direct participation is the one who took a direct part in the execution of the crime. Principal by inducement is those who directly force or induce another to commit the crime. So yung tandaan nyo to, pwedeng nag-induce siya, kaya inducement, pero who directly force as well. Nagpuwersa siya ng isang tao, hindi lang nag-induce nagpuwersa siya ng isang tao to commit the crime. So these two are distinct and separate. Those who directly force and the one is those who directly induce others to commit the crime. When you talk about principal by indispensable cooperation, tatandaan nyo rito, his cooperation is, without his cooperation, the crime would not have been committed. Without his participation, the crime would not have been committed. Kaya nga tinawag na indispensable. Pag hindi indispensable yan, hindi siya indispensable cooperation. Most probably, accomplice lang siya. Ha? Yun. So we will be discussing those three uh, individually. We will discuss that. Now, tatandaan nyo, kanina, like felonies are punishable only, okay, when they have been consummated, but when like felonies are committed against persons or property, okay, they are punishable even if they are only in the attempted or frustrated stage of execution. Third is only principals and accomplices are liable for like felonies. And also, accessories are not liable for felonies even if they are committed against persons or property. Now, only the officers of the corporation who participated either as principals by direct participation or by inducement or by cooperation, or as an accomplice in the commission of an act which is punishable by law, are punishable. Now, remember yung principle ng conspiracy natin dati, mag-a-apply yan dito sa principle by direct participation. Okay. Difference between a principal under any of these three categories enumerated under Article 17 and a co-conspirator. The difference between an accused who is a principal under this Article 17 and a co-conspirator who is also a principal is that while the former's liability is limited to his own acts as a general rule, yung liability ang liability ng co-conspirator includes the acts of his fellow co-conspirators. You know that already. So two or more persons who may take a direct part in the execution of an act, in which case there may be a principal by direct participation. Two or more persons who took part in the commission of the crime are principals by direct participation when the following requisites are present. Number one, that they participated in the criminal resolution. So they participated in the criminal resolution and that they carried out their plan. uh, A and B are cousins and that they carried out their plan and took part in the execution by acts which directly tended to the same end. So una-una, let's discuss on first requisite, participation in the criminal resolution. So we discussed this already. When two or more persons are said to have participated in the criminal resolution, when they acted in conspiracy at the time of the commission of the felony. So it is well settled that in our jurisdiction that a person may be convicted for the criminal act of another when there is conspiracy, whether it's expressed or implied, when there is unity of purpose and intention in the commission of the crime charge. And let's just review. We discussed it already, but let's just review. Conspiracy. To be a party to conspiracy, one must have the intention to participate in the transaction with a view in the furtherance of the furtherance of a common design and purpose. So kung mere knowledge lang or approval of the act, wala namang pinapakita that there is an agreement to cooperate, is not enough to constitute one a party to a conspiracy. And of course, as I emphasized earlier, conspiracy must be proved by positive and convincing evidence. So it cannot just merely presume, it cannot be based on suspicion, but it must be proved as the crime itself. Now, there's only a hairline distinction. If there's conspiracy, then liable sila. I can be liable for the acts of other co-conspirators. Ganun yun. For as long as we committed our part, our role based on the conspiracy in furtherance of the same criminal resolution and design. However, if there is no conspiracy, then each of the offender is liable only for the act performed by him. So one can be a principal by direct participation, one can be an accomplice. Kaya nga basic ang principle na kung merong kung may conspiracy, then lahat sila is a principal by direct participation. Pag walang conspiracy, okay, one can be a principal by direct participation and one can be an accomplice. Remember, pamaya, we will discuss, pag accomplice, no, dapat walang conspiracy. Bakit? Kasi kung may conspiracy, hindi dapat accomplice. Dapat principal yun. Okay? So, participation in criminal resolution is essential. It is not enough that a person participated in the assault made by another in order to consider him a co-principal in the crime committed. He must also participate in the criminal resolution of the other. So, if you can remember, no, yung active cooperation by all the offenders in the commission of the crime will shows that there is unity of purpose and intention. So spontaneous agreement at the moment of the commission of the crime is also sufficient to create a joint responsibility. When there is a band, conspiracy is presumed when the crime is committed by a band. Pwede ba magka-conspiracy, sir, kung walang evident premeditation? Yes, there may be conspiracy even if there is no evident premeditation on the part of the accused. Kasi nga, pwede at the moment, it can be shown at the moment of the execution of the crime. Okay, liability again, when there is a conspiracy, the act of one is the act of all. There is collective responsibility. So pag sinabing, ikaw, look out ka lang, ikaw, driver, ikaw ang papatay sa isang tao. So ang liability ng pumatay ng tao, the same as that of liability ng driver lang or ng lookout lang. Because the act of one is the act of all. Again, as I emphasized before, a conspiracy is not liable for another's crime, which is not an object of the conspiracy. Okay? In other words, a co-conspirator is liable only for the acts that they perform in pursuant to conspiracy. If that is not the object of conspiracy, if a person perform a different an act separate and different or distinct from that which they agreed upon, others are not liable. They're only liable for co-conspirators are liable only for the conspiracy that they agreed to commit. That's the general rule, di ba? At in-emphasize ko lang, ang pwedeng hindi mag-fall dyan ay yung special complex crime like robbery with rape, robbery with homicide kasi it has its own rule. Ang own rule niya is if by reason or an occasion of robbery somebody was killed, okay, a homicide is committed, then all of them will be liable even if that is not the object of conspiracy. So, pag special complex crime, hindi mag-a-apply. Pag hindi nag-fall sa special complex crime, is liable for the crime that they conspired to commit only. Yun lang ang limited liability niya. A person in conspiracy with others who had desisted before the crime was committed by the others is not criminally liable. Mere conspiracy is not punishable unless if it involves conspiracy to except when conspiracy is punished by a law, like conspiracy to commit treason, rebellion, sedition, coup d'etat, and terrorism. When there is conspiracy, it is not necessary to ascertain the specific act of each co-conspirator. It is not necessary to ascertain the specific acts of aggression committed by each of the culprits. No? Since having participated in the criminal resolution, the act of one is the act of one. So kung may conspiracy na clearly established, immaterial na nga whether yung isang co-conspirator ang bumaril o hindi. Kasi the fact na may bumaril isa sa kanila liable na sila. For as long as it can be proven that conspiracy exists. Question, sir, can there be a conspiracy through negligence? There could be no conspiracy to commit an offense through negligence. Kasi nga, di ba, pag may conspiracy, it presupposes na merong prior agreement or a decision to commit a felony. Pagka ang napakita is that the injuries inflicted on the offended party were due to a reckless imprudence of one or two or more persons, it is not proper to consider conspiracy between or among the participants, among them. Okay. Let's go to the second requisite. So kanina, dapat they participated on the criminal resolution. The second requisite is that principal, they have participated. Principals by direct participation must be at the scene of the crime. There should be, they must be at the scene of the crime, personally taking part in its execution. Must personally take part in executing the criminal plan to be carried out. So, ibig sabihin yun, dapat nandun sila at the scene of the commission of the crime and taking first part personally in the execution thereof. So kung di na ipakita tong second requisite, then the second requisite is lacking. There is only mere conspiracy. So yung kanina sinabi kong principles, pag-apply. Mere conspiracy is not applicable unless there is a law that punishes the act. Let's go principle by inducement. There are two ways. Nakalagay dyan by directly forcing another to commit a crime, and secondly is by directly inducing another to commit a crime. Yung directly forcing a crime. So merong principle by direct participate. Merong principle na nag-induce at merong taong nag-execute ng material crime. No? Meron ba liability yung taong sumunod sa kanya if it is directly forcing another to commit a crime? By directly forcing another to commit a crime, wala. Because it is perhaps they use either irresistible force, kasi nga sinabi force eh. So pag gumamit ng irresistible force, ay at by causing uncontrollable fear. Exempting circumstances yung dalawang ito, as you mentioned, as you recall. Pag merong irresistible force, no, at sinunod niya yung inducement kasi merong irresistible force, walang liability on his part. Or merong uncontrollable fear of an equal or greater injury. No? You cannot consider na merong conspiracy dito. No? Kasi wala namang unity of criminal purpose and intention eh. One, napwesa lang siya. The material executor is not criminally liable if there is irresistible force or uncontrollable fear, no? Committed. Yung nag-induce, yung directly forcing another to commit a crime, siya ang liable. Pagka hindi naman force, pag-inducement, ay iba usapan na yan. There are two ways of directly inducing another person to commit a crime. Okay? Number one, by giving prize or offering a reward or promise. And secondly, alam naman natin to, or by using words of command. Okay? So, anong mga requisites? So, in order that person may be convicted as a principal by inducement under this second way, okay? That number one is that the inducement, the inducements must be made directly with the intention of procuring the commission of the crime. Okay, number one is with the intention of procuring the commission of the crime. Secondly, yung inducement must be the determining factor or the determining cause in the commission of the crime by the material executor. Ibig sabihin, hindi niya gagawin ng krimen if it is without the inducement. Okay? So iyon ang it must be the determining cause for the commission of the crime. Ergo, yung mga comment na a thoughtless expression without the intention to produce the result is not an inducement to commit a crime. Yung thoughtless expression or act without any expectation or intention that it will produce the result is not an inducement to commit a crime. Yung chance words lang, without reflection. Pag sabi, ay, patayin kita eh. Ay, di ba? Mga ganong expression lang. When you can show that there is actually no intention to produce the crime, it's not an inducement to commit the crime. Ha? Mamaya papatay kita eh. Ganong biruan. But the words of advice or influence must have actually moved the hand of the principal by direct participation. Halimbawa, yung person, ipinersuade niya yung inexperienced boy na isang minor to steal yung jewelries ng kanyang grandmother, was found guilty of theft by inducement. So, ano yun? Liable. The inducement must precede the act induced, and it must be so influential in producing the criminal act that it would not, no, that without such, no, the act would not have been performed. Pag sinabing words of command, no, it must be the moving cause of the offense. It must appear that the inducement was of such nature and was made in such a way as to become the determining cause of the crime. And that such inducement was uttered with the intention of producing the result. So in order that the person using the words of command may be held liable as principals, then ito ang dapat niyong intindihin. No, i-memorize. Merong 5 requisites. There are 5 requisites which must all be present. No? Words of command. Number 1 is the one uttering the words of command must have the intention, of course, of procuring the commission of the crime. Second, that the one who made the command must have an ascendancy or merong siyang influence over the person who acted. Second, the one who made the command must have an ascendancy or influence over the person who acted. Third, the words used must be so direct or efficacious, so powerful as to amount to physical or moral coercion. As to amount to a physical or moral coercion. And number 4 is that the words of command must be uttered, of course, prior to the commission of the crime. No, it must be uttered prior to the commission of the crime. And number 5, lastly, the material executor of the crime has no personal reason to commit the crime. No, he has no reason to commit the crime. Kasi dapat nga the inducement must, without the inducement, the crime would not have been committed. Eh kung meron na silang existing grudge between the two of them, no? Bonus na lang yung inducement, then this will not be considered. Okay? Kasi meron siyang ibang motibo. Eh. So paano mo how do you distinguish a principal by inducement, no, who made a proposal to commit a felony? No? So a principal by inducement from those who made proposal to commit a felony. So in both, there is inducement to commit a crime. In the first, yung principal by inducement becomes liable only when the crime is committed by the principal by direct participation. In the second, mere proposal to commit a felony is punishable in treason or rebellion. The person to whom proposal is made should not commit the crime. So otherwise, the proponent will now become a principal by inducement. So hindi na lang siya proposal. Third is the inducement involves a crime. Inducement involves the crime. In second, proposal is to be punishable must only involve treason or the crime of rebellion. Kasi doon lang siya nag-apply. Important principles to be considered, no? There is a principle by inducement or by if it is shown that the crime was actually committed by another who was induced. Okay?